Why did I argue in my previous video that UK constitutional and administrative law seek to address the problems raised by Lord Acton's comment about power tends to corrupt? British constitutional law is the traditional approach. It seeks to put controls on the use of power, and two of the key ideas are of ministerial responsibility, that when ministers take decisions, they are responsible before Parliament, they have to answer questions, they have to explain their actions before Parliament, should MPs so require it. And the existence of conventions, these non-legally binding rules which political actors regard themselves as bound by, and that have had a tremendous impact on the way that politics and governance is practiced in the UK. That was the traditional approach. But of course, in recent years, there's been criticisms that Parliament hasn't perhaps stood up to the executive as much as it should. And so we've seen the development of the British form of judicial review, and I would distinguish that from the American, which is about striking down legislation. British judicial review is about the courts reviewing a decision, not for the decision itself, but for the way that the decision is taken, and so looks at issues about, is there bias there? Is the decision irrational? Have procedural rules not been followed? So here's a way that the law seeks to address the very real need to address the issue of the low-level corruption, which I argued in the previous video is a part of human nature. Thank you.